In the world of surgery, some of the riskiest decisions you'll make don't involve a scalpel at all. They happen in the conversation you have with your patient before the procedure even begins. So in this explainer, we're going to navigate the legal minefield of surgical consent, especially when you find something unexpected on the operating table.
And let's be really clear about this right from the start. This is the crucial point. You can perform a technically perfect surgery, a flawless operation, but if the consent process was flawed, you're still exposed. The real legal risk isn't just about your skill in the OR, it's about the quality of that conversation you had with your patient long before they're on the table.
So, here's our roadmap. First, we'll pinpoint the real lawsuit risk. Then we'll break down the core principles of what makes consent legally valid. After that, we'll tackle the big one: how to handle unexpected findings intraoperatively. We'll also look at a landmark legal case, the Samira Kohli standard. And finally, we'll wrap up with a practical, step-by-step process for defensible consent.
Okay, so why is consent such a hotbed for litigation in surgery? Well, it really boils down to a fundamental conflict. The law demands certainty and clear authorization from the patient, but the reality of surgery is, it's anything but certain. It's dynamic, and things can change in an instant.
And this is the core tension, right here. The law is built around a plan that's been clearly explained and authorized beforehand. But once you're in the OR, you might discover things you never anticipated. It's that gap, the space between the original plan and the on-the-table reality, that creates a massive legal vulnerability.
So to protect yourself and your patient, we have to be crystal clear on what the law actually considers valid consent. And let me tell you, it is so much more than just a signature on a form. It's a structured process, and it rests on 5 essential legal pillars.
For your consent process to be legally defensible, you need all 5 of these in place. First up is disclosure. That means explaining the risks, benefits, and alternatives. That leads to comprehension. You have to be sure the patient truly understands what you've told them. The decision also has to be voluntary, made without any pressure. Of course, the patient has to be legally competent to make the decision. And finally, the whole conversation needs thorough documentation. A failure in just one of these pillars can bring the whole thing crashing down.
Now, surgical consent isn't like other medical consent, and here's why. It all comes down to one simple fact. Under anesthesia, your patient is incapacitated. They can't give you new instructions or fresh consent. That means the consent you get beforehand has to be incredibly robust. It has to cover not just Plan A, but also potential contingencies and unforeseen issues that might come up.
Which brings us right to the heart of the matter. You're mid-procedure, you find something you weren't expecting. What do? What are your legal and ethical obligations in that exact moment? This is the million-dollar question, isn't it? Your patient is unable to communicate, the clock is ticking, and you have to make a call. The law thankfully does give us a framework for this, but you need to know that this framework is very specific and extremely narrow. The legal principle that governs this is called implied consent for extension of procedure. Now, the key word here is extension, not addition. This is not a green light to perform other elective or opportunistic procedures you happen to find. Think of it as a safety net, reserved only for immediate life or limb-threatening emergencies.
So when can you legally extend a procedure? The conditions are strict. You can only proceed if not acting would pose an immediate threat to the patient's life or lead to a serious permanent disability. It's a shield to protect you when you have to make a life-saving call, but it should never be used as a sword for discretionary actions.
And on the flip side, the law draws some very clear lines in the sand. Things like performing a sterilization, removing a non-threatening organ, or making a cosmetic tweak are absolutely off-limits without explicit prior consent. In these situations, where there's no immediate emergency, the patient's right to decide for themselves, their autonomy, always wins.
Now, to really hammer this point home, let's look at a landmark legal case from India's Supreme Court. The case of Samira Kohli versus Dr. Prabhaman Chanda set a powerful standard that has relevance for surgeons all over the world, because it defines the limits of a surgeon's discretion so clearly.
The court's ruling was completely unambiguous. It essentially drew a bright line, saying that a surgeon simply does not have the authority to perform an additional unconsented procedure, with one single exception, when it's absolutely necessary right then and there to save the patient's life or prevent grave harm.
So, the court established a few critical principles that we all need to live by. First, it completely invalidated the idea of blanket consent. You know, those vague forms that say the surgeon can do whatever they think is necessary. Second, it confirmed that any additional unrelated procedures need their own specific consent. And third, it drove home the point that in non-emergencies, patient autonomy trumps surgeon discretion, period.
All right, so now that we understand the legal landscape, let's get practical. How do we build a consent process that is both centered on the patient and legally bulletproof? Here are the actionable steps you can take. This is your playbook. 1. Stop using generic templates and start using procedure-specific forms. 2. Have a detailed discussion about contingencies, like the possibility of converting from laparoscopic to open, and document that talk. 3. Get consent well in advance, never on the day of surgery when the patient is stressed. 4. If you do have to make an intraoperative call, document your reasoning meticulously in the patient's record. And finally, number 6. Always close the communication loop. Have a thorough post-op debrief with the patient and their family. It all comes down to transparency.
If you take away only one thing today, let it be this. A signed form is just a piece of paper. It's evidence that a process happened. Your real legal protection, your real shield, is found in the quality of the conversation you have with your patient. A conversation built on transparency, planning for the unexpected, and a deep respect for their right to make their own decisions.